This presentation is focused on three further basic elements necessary for the formation of contract. 1. That the parties intend to create legal relations. 2. That the terms of their agreement are certain and not vague. And 3. That their agreement is a complete agreement that does not need further development or clarification. It is essential that all parties to an agreement have the intention to create legal relations. What this means is that the parties intend that legal consequences attach to their agreement. In short, the parties intend that the agreement will be binding with recourse to some external adjudicator, a court or arbitrator, for its enforceability. The necessity for intention is most evident in domestic and social agreements. Traditionally, the law has distinguished between domestic and social agreements and commercial agreements. In the case of domestic and social agreements, it is presumed that there is not an intention to create legal relations. In the case of commercial agreements, it is presumed that there is an intention to create legal relations. In either instance, the facts of the case may displace the presumption the law would otherwise make. The determination of whether or not the parties intended to enter into a legally binding relation is an objective one, and context is all important. What this means is that the courts will not examine the states of mind of the parties to the agreement, which would be a subjective approach, but will ask whether or not reasonable parties to such an agreement would possess an intention to create legal relations. This objective approach applies regardless of whether the agreement is a social or domestic one or a commercial one. Increasingly in the modern world, domestic arrangements are beginning to take on a basis in contract. Balfour versus Balfour is a case that must be seen as one that establishes a rebuttable presumption that domestic agreements are not intended. An example of a situation in which the presumption was rebutted can be found in the decision in Merritt versus Merritt in 1970. In relation to commercial agreements, courts will generally presume that an intention to create legal relations is present. See, for example, Esso Petroleum versus Commissioners of Custom and Excise from 1976. An enforceable contract requires certainty of terms. That is to say, for an agreement to be a contract, it must be apparent what the terms of the contract are. If an important term is not settled, the agreement is then not a contract. In Scammell versus Austin in 1941, the court found that the agreement was not enforceable because the terms were uncertain and required further agreement between the parties. Viscount Maugham explained that because the terms were uncertain, there was no real agreement between the parties. The underlying rationale for this area of the law can be seen in that if the terms cannot be determined with certainty, there is no contract for the court to interpret. It is not the role of the court to create the terms of the contract, for this would be to impose a contract upon the parties. In some circumstances, particularly where the parties have relied upon an agreement, courts will more readily imply or infer a term. This can be seen in the decision in Hillas versus Arcos in 1932. Here, the agreement had been relied upon, and the court was able to infer the intention of the parties based upon the terms in their agreement and the usage in the trade. To create an enforceable contract, parties must reach an agreement on all the major elements of their contract. The agreement must, in other words, be complete. There must be nothing left outstanding to be agreed upon at a later date. Completeness is an aspect of certainty of terms. Unless an agreement is complete, a court is unable to state with certainty what agreement has been made between the parties. If there is no agreement on all of the essential elements of a bargain, there is no contract. There must be an agreement on matters such as price, either by fixing the price or establishing a mechanism to fix the price. What is essential in a contract will depend upon the nature of the contract. There is no such thing as an agreement to agree. The reason for this probably lies in the practical consideration that if the agreement is incomplete, it is not for the court to complete the agreement because the court would then be creating rather than interpreting a contract.